Good morning, Your Honor.
Good morning. All right. And there's an attorney, Kennedy Shannon. Do you know what that is that on this case or no?
Yes, with my office.
Oh, okay. All right. Well, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, continuing our civil docket, and we are providing public access both in the courtroom and also online. And up next, I've got a motion for summary disposition in Estate of Wiggins v. Wiggins, filed 24-9024CH. Counsel, you want to state your appearances, please, beginning with the plaintiff?
Oh, excuse me, Laura McMahon Lynch, on behalf of the plaintiffs, Amelia Wiggins and estate of Betty Geraldine Wiggins.
Good morning, Your Honor. Alexandria Taylor on behalf of the defendants.
Okay, good morning. And this is your motion for summary disposition, Ms. Taylor. Before you get into your argument, I have just a couple of quick questions for you. One is, because looking at the file, I've got all these motions for alternate service that have been filed and whatnot. How many of these defendants and which of them do you represent?
So, Your Honor, I represent the family of Jacqueline Wiggins and of Anna. Theron is deceased.
Well, hang on.
Yes.
Hang on. So family of, okay. So if I'm looking at the case caption, and I'm sorry, I just didn't go through and look at all of the. I mean, when you file the motion and it says you're the attorney for defendants, can we go through the caption and you can clarify for me which of the defendants you represent then? Gail Wiggins?
Hold on one second, Your Honor. Yes, Gail Wiggins.
Okay. Kai Smith?
Yes.
Kim Savage?
Yes.
Donna Wiggins?
Yes.
Daryl Wiggins?
Yes.
Christina Wiggins?
Yes.
Anna Bolden?
Yes.
Reginald Wiggins?
Yes.
Ronald Wiggins?
Yes.
Victoria Thrasher?
Yes.
Cheryl Adams?
Yes.
Estate of Cynthia Ruffin?
Cynthia Wiggins. Yes.
Okay. Estate of Leonard Wiggins?
Yes.
Estate of Theron Wiggins?
No.
Okay. Estate of Irvin Wiggins?
Yes.
And estate of Jacqueline Wiggins?
Yes.
Okay, so you represent all the defendants except the estate of Theron Wiggins, is that right?
Yes.
Okay, and Ms. Lynch, is that consistent with your understanding of the status of the case in terms of service and representation?
You know, I take exception with that.
Yeah, because I signed an order yesterday where you're saying I need alternate service on Reginald Wiggins, and Ms. Taylor saying she's representing him.
We had a conversation, Your Honor, some weeks ago, and she said she had a spokesman for the Wiggins family. I have drafted a motion to disclose her retention agreements because I don't understand her representation of estates that have no personal representative. Her response on the phone about that was that she had to consult with her probate attorney. But just as a matter of course, I don't think there's any authority for her to be representing estates absent some kind of court order. With regard to, there is one error in the caption that you read off, and that is also a housekeeping matter that I was going to seek some direction on. There is another defendant, it was Edward Ruffin, who is the husband of the deceased Cynthia Ruffin. He is named in the verified complaint and in the first amended verified complaint as a defendant. A summons was issued from the verified complaint. He was served, proof served, filed. So I asked about Mr. Ruffin, and counsel was asking me for his contact information because there have been settlement offers, and pursuant to MCR PC 1.4, the offer of settlement should be made to each defendant.
Okay, well,
They should be aware of what's being offered. The fact that she wants me to give her the contact information for a defendant she's supposedly representing is troublesome to me.
all right, so before we go any further then, I just want to clarify this then. So Ms. Taylor, there's no answer that's been filed, right? Your motion for summary disposition is the responsive pleading you're filing. Am I right?
That is correct, Your Honor.
Okay, so there's all these defendants, some of them estates, and I'm signing orders for alternate service. And so you didn't file like an appearance, did you, for who you're representing? You just filed the motion for summary disposition as a responsive pleading. Am I correct about that?
Yes, Your Honor. And if I can comment, so when counsel communicated the settlement was as to all defendants. And so it wasn't just a settlement as to one family. She communicated that as to all. And then I had a communication with the individuals. I don't recall what counsel is speaking about. She communicated
Okay,
that.
well, I don't care about.
Just speak to the.
Hang on. I don't care about the settlement stuff. Here's what I care about. I've got a case with like more than a dozen defendants. I've got all these motions and orders for alternate service out here that I'm signing. And so the plaintiff is saying they don't even have some parties served. I get a defense. I don't get an appearance or an answer from any of the defendants. I get a pleading filed by Ms. Taylor that says it's a motion for summary disposition. And she just says she's the attorney for defendants, but doesn't tell me which ones. And then I asked what ought to be a simple question. Which defendants does Ms. Taylor represent? And I'm not getting any clear answer from the two attorneys. I like to use this line sometimes. I'll use it today. There are many mysteries in the universe. Who a lawyer represents ought not be one of them. I can't see how I can possibly proceed today, Ms. Taylor, with me not even knowing who's this motion for summary disposition filed on behalf of. My second issue to you is then there's a motion. Then there was an amended complaint filed after your motion. Does that require you to amend your motion or render it moot in any way, or where are we at on that?
Well, Your Honor, first of all, and then my co-counsel can speak to it. But when we went through the list, Your Honor went through the list and asked me, and then I said yes to the ones that I did represent. So I'm sorry if there was some misunderstanding in that.
The caption on your pleading left one of them off, right?
Yeah.
So Edward Ruffin. So the caption, you file a motion disposition saying for defendants.
Yes.
And and it doesn't say which defendants you're representing. I find out today it's not all of them. And then the caption that you had on your pleading leaves one of the defendants off. So, I mean, do you understand where I'm coming from? I mean, I need to know, let's say I grant your motion. I need to know what portions of the case are being adjudicated and what portions of the case may yet be alive, don't I?
Yes. And the second thing, Your Honor, pursuant to the court rule, I thought that you had to do motion for leave to file an amendment because we've answered it. And so that.
No, well, I don't know who's answered it.
Your Honor.
Let me ask you this then.
Your Honor, can my co-counsel speak?
Your Honor, Kennedy.
No,
I'm sorry.
I'd prefer.
Can I make a response, Your Honor? First of all, it's not a responsive pleading. A motion is not a
for summary
responsive pleading.
disposition can be filed in lieu of one. Yeah.
Right, but under 2.110, a pleading is either a complaint, a cross complaint, a counter complaint, a third party complaint, or an answer to one of those. So I had perfect right to amend the complaint without any leave because no responsive pleading has been filed at this moment under 2.118.
Okay.
But that is a
Well,
responsive.
Your Honor, if I might.
Let's maybe set aside my procedural problems with this and just get to the merits of your motion, Ms. Taylor. When I read your brief, isn't your brief just a whole bunch of factual disputations? And how could that possibly be the basis for summary disposition prior to discovery? The plaintiff filed this complaint, and your motion for summary disposition just says, no, it's all these other facts instead. How is this ripe for summary disposition today?
Well, Your Honor, there are no facts in dispute on the ownership. That's a legal question. So that is not in dispute, Your Honor. And second, there is an open probate case. And so probate court is a court to decide interest. And so that's the other thing. I mean, this to me is improperly before this court because I confirmed that the probate matter is still open. And so if there is a question as to the interest in a decedent's estate, that is a matter that is best handled by the probate court.
Right, but I mean, you haven't attached a single exhibit or documentary or citation really to any record anywhere in your motion or brief.
We did have exhibits on there, and there is case law, Your Honor. So when you say there's no citations, what citations are you referring to?
No, citations to the record. So there's these exhibits, but you don't.
Right, I was going to say, because if there aren't any exhibits, then that's a mistake, because what I'm bringing up is 34 pages that were filed. And there are exhibits that are filed in there, and there are case law citations as well.
Sure, but where in your motion or brief do you make a citation to any of those specific exhibits? I see none.
In the
But
motion.
What's that?
I'm sorry, what did you say, Your Honor?
Well, I mean, clearly you and Ms. Lynch know a lot about the facts of these folks, and I know none of those things. So when I read a motion filed by an attorney, and your motion has 15 numbered paragraphs, and not one of them makes reference to, it just says, see attached exhibit A, emails and payment of expenses. That's the only citation to a record that doesn't like point me to specific things in it. And then there's a brief that's very, very short, like 4 or 5 pages. Again, no reference to anything specific in the exhibits. And then a stack of exhibits. I guess your pleadings, I don't know these folks. I don't know these facts, and I can't possibly know what to do with this case by reading your motion or brief. What is it you'd like me to do today, Ms. Taylor?
Well, Your Honor, what we would like you to do is to dismiss this case because there is no legal question. There is no issue of the law here. The deed is clear in that there was a 25% interest to 4 individuals, and this is a family cabin. And this is something that was acknowledged by—
So what deed? You filed a motion for summary disposition. You don't even attach the deed and point that out.
But the deed was attached to plaintiff's complaint, Your Honor. So that's the deed that I'm referencing is in plaintiff's complaint. The deed that plaintiff attached, there's no question as to this deed and the interest, and it's simply that plaintiff wants to take the property, this family property, and essentially disinherit 40 family members. And so there is no legal question. And so the things that were argued, the categories in plaintiff's complaint, those categories are addressed in the motion. The unjust enrichment, which plaintiff is arguing that there's going to be unjust enrichment because her mother paid all the expenses for the cabin. Well, that's the exhibits. The exhibits show that simply did not happen. And that actually covers their point, count 1 and 2 for contribution. The adverse possession, we cite the law, is the legal argument, why that argument fails. And then the quiet title, which is subsection
you
E.
cite the argument, you cite an argument about adverse possession, but then you just tell me a bunch of facts. How do I know if there's a true? Isn't that what litigation is for? You don't get to just file a motion with a bunch of factual assertions with no record evidence and then expect the judge to make the case go away for you. I'm going to deny the motion for summary disposition. It's a confusing mess. I don't even know if it's filed under C8 or C10. I don't know which defendants Ms. Taylor is representing. And the motion and brief would leave it to this court to research and ascertain the facts and the legal theories behind the defendant's motion. I consider all those arguments abandoned for inadequate briefing. The motion's dismissed, or the motion's denied without prejudice.
Your Honor, may I raise one issue?
There's nothing before me yet today.
Well, it is in my brief. We asked for judgment pursuant to
Same
I2.
issue. Your brief was just as bad. I have no idea. You both are filing briefs with me, just telling me a bunch of facts. I don't get to decide a case just on what. Yeah, that's denied as well. You guys need to do a better job with your pleadings. Thank you.
Thank you, Your Honor.
Mr. Martin.
Your Honor,